Hello, everyone. My name is Sivan Tumarkin, and I am a disability lawyer with Samfiru Tumarkin, co-founding partner. And we are here today to talk about long-term disability. And I want to start off with a question that I receive now almost on a daily basis from people across Canada. And that has to do with applying for short-term disability or long-term disability as a result of psychological issues generated by the instability of the world. We are living in a bit of a crazy world right now. A lot of people are very, very concerned financially because of the tariffs from the States, because of what's happening just in general in the world politically, south of the border, etc. And so the kind of questions that I get are, look, I'm feeling tremendous anxiety about my job. I don't know if I'm going to lose it. I can't sleep. I can't function properly because of what I'm experiencing. Of course, I always ask people when they tell me that, have you spoken to your doctor? And oftentimes they say yes. And oftentimes, when they say yes, they also tell me that the doctor has recommended that they, in fact, take time off and go on disability leave if they have it. And so I tell people, look, here's the way it works. Many workplaces have health benefits for their employees. Many of those health benefits packages contain short-term and or long-term disability coverage. And to apply for that is actually not that difficult. Essentially, the test is this. If you're unable to work because of either a psychological issue, condition, disorder, or perhaps because of a physical issue that's manifested, or maybe a combination of both, maybe because of your psychological issues, depression, anxiety, phobia, PTSD, whatever it is, perhaps because of that you can't work. Well, if you and your doctor are on the same page, then you can apply for short-term disability. And some people have that privately, that kind of coverage. It's not through work, but most people have it through work coverage. The insurance company should not deny you that kind of a claim if your doctor is on board saying that you cannot work because of the particular issue you're experiencing. So that's something really important to understand because people don't even think about that. They simply assume, okay, I'm going to be let go from my job. I can't function now anyways. Why does it matter? Well, here's why it matters. If you go on disability, if you apply for short-term or long-term disability and you are approved, then even if your company goes out of business or if your company shuts down or gets sold, because you're already on plan, you're already on disability, that disability coverage continues. It doesn't matter that the company is now out of business. It's almost like a lifeline that you have. Of course, again, the caveat here is that you're unable to work because of whatever symptoms you're experiencing. So really important to understand here that this is something that is available to a lot of people, but you're not necessarily thinking about it. People don't necessarily think that they would qualify for disability as a result of these kinds of issues, which have to do with external factors like the tariffs or like, the stress of potentially losing your job. I want to go to some questions now that we have, and I'll get back to my points a bit later. This is a question from Facebook from Paul. Are you able to help with disability claims for union employees? Yes, for the vast majority of union employees, we can in fact help. Now, it does depend on certain factors. It depends on what the collective agreement for the union, for the unionized employee says. In some instances, we're precluded. You have to use union lawyers. The problem with union lawyers is that they don't really have disability experience. They deal with workplace issues. But the general answer, I would say, is it depends, Paul, but in many cases, yes, we can help unionized employees with their short-term or long-term disability matters. And I tell people, just reach out to us. It doesn't cost anything to check and for us to tell you, number one, if we can help, and number two, if you have a case, okay? Another question here. My short-term disability request got denied for mental health stress leave. My doctor listed all of my symptoms and severe anxiety and panic attacks on the form, and yet the insurance company representative said that there is not enough evidence. Another colleague got accepted last year for the same reasons, and our forms almost look identical. Any reason why? I'm appealing as well. How can I make sure I get accepted? A lot to unpack here. So insurance companies, and this is just the practical reality of coverage of disability, is that insurance companies, if you boil it down, they're made up of people, just like most companies, right? And so the people who are making decisions here as to whether or not your claim will be accepted, they're adjusters. They're front-level adjusters, front-facing adjusters. They're the one who are looking at a claim, making an assessment as to whether or not you should be accepted based on the evidence, etc. If you have two different adjusters, much like you have two different people going to a restaurant, one person having a good experience, the other one saying, no, it's not that good, same kind of thing. Just like going to two different doctors who may give you different types of advice, two different lawyers. So the fact that you were denied doesn't mean that you ought to have been denied, doesn't mean that you don't have recourse, doesn't mean that you have no claim. This is where we come in. And this is where I tell people, don't accept a denial. Do not accept it at face value. Don't assume that the insurance company is correct. They make mistakes all the time. If they didn't make mistakes, if they didn't do their job, if they did their job 100% correct, people like me would have no work. And maybe that's good for most people, but the reality is that most insurance companies simply operate like other companies where they make mistakes sometimes. And, frankly, sometimes adjusters, there's other incentives for them or other motivation for them to say, we're not going to accept this claim. So the fact that one of your colleagues got accepted and you did not doesn't surprise me. I say this all the time. What I can tell you is that I would want to see the form that was submitted. I would want to talk to you. I would want to understand exactly what your limitations are. And I'll tell you within a few seconds whether or not I think that you should be accepted, whether or not the insurance company is correct or not. And if the insurance company is not correct, there are options. You have options. Now, you've mentioned that you're proceeding with an appeal. You can. Nobody's stopping you from appealing. Insurance companies love when people go the appeal route because essentially they're keeping you within their box. They're keeping you within kind of their frame. Who are you appealing to? You're not appealing to a court. You're not appealing to a tribunal. You're not appealing to a third party. You're appealing to the same company that denied you in the first place. And so, no surprise, the majority of appeals fail. The majority of appeals go nowhere. Ironically, when people get rejected on their appeal, they're then offered to appeal the denial of the appeal, et cetera, et cetera, et cetera. And so what happens is that most people end up just saying, forget about it, it's too much. I don't have the the endurance for it, the mental endurance. I just don't want to deal with it. The problem with that is that you end up leaving a lot of money potentially that's owed to you on the table, or worse yet, in the pockets of the insurance company. So again, it doesn't cost anything to talk to me, a member of my team. This is what we do, and we do this across the country. With the exception of a few places like Quebec, where they have different laws, we literally answer these kinds of questions day in and day out from folks across Canada. So feel free to reach out to me directly after the live stream or at any point, really. Another question that just came from Anita. My sister has recently been diagnosed with chronic fatigue and fibromyalgia and is struggling to get her LTD approved. She's on her second appeal. What more should she give the insurer to help? There you go. Point made. On her second appeal, it aggravates me to no end that people who are struggling, people who are truly in dire financial situations, physical, medical, psychological conditions, have to go through this hamster wheel that just keeps spinning, and the insurance company is completely oblivious to the damage they're doing along the way. And there is damage being done because people don't only get frustrated, but there's economic damage. Some people can't afford to actually pay their rent, let alone pay for food and make sure that that their kids have everything they need. So to answer your question, Anita, I would stop with the appeals right now. I mean, again, if your sister wants to continue, she can. The reality is that if her doctors put down on paper that she's unable to work because of fibromyalgia or whatever symptoms are bothering her, and clearly she can't, she should get approved. And there is a very easy way of forcing the insurance company to the table, and that's a legal action. And I know some people out there are going to say, well, you're a lawyer, of course you're advocating for that. I'm advocating for that because that is the only thing that the insurance company can't do whatever they want. In other words, if you're appealing, you're playing within their rules. You're essentially subject to their decision making. When we start a legal action, let me explain to you what happens. Incidentally, I used to be an insurance lawyer 20 years ago. I used to work for insurance companies. That's how I started my career. So let me tell you what happens. When you go after an insurance company, your file moves from the department, the initial department where your claim was being handled, to a different department that deals with claims, with legal claims. That means that typically there's another adjuster, an adjuster that deals with legal claims. And this is key, The insurance company puts a defense lawyer now on the file, on your claim. That defense lawyer is either an in-house lawyer, somebody that they employ, or a lawyer like myself that works at a firm. Here's the problem for the insurance company. Here's why they hate it when we do this. Because it means that now they have to spend money defending your case. If it's just an adjuster looking at a file, no problem. They can do this all day. They're being paid a salary. If it's a lawyer, well, that's very, very different. Now they have to pay. Now they're bleeding money. That's how I describe it. And the one thing insurance companies hate more than paying a legitimate claim is paying their lawyers to defend a legitimate claim. So keep that in mind. Legal action, legal recourse is extremely powerful. It levels the playing field, oftentimes tilts it in your favor, because if you can imagine, courts, judges are not necessarily too sympathetic to insurance companies, and insurance companies know it. And I know they know it because I used to work for them, and I used to tell them, be careful of taking this to court. Okay, a lot of questions coming in, so I want to make sure I get to them. Question from Alexandra from YouTube. I am currently off on short-term disability, but my doctors have said that there is no way I can return to work in the near future. I need to transition to LTD, long-term disability. But I'm worried about talking to my insurer and saying the wrong thing. How should I approach this? What should I do before speaking to my insurer? Excellent question. First of all, as long as you're telling the truth, as long as your doctor is telling the truth, as long as you're providing that medical support from your doctor or doctors or any other treatment providers, physiotherapists, acupuncturists, massage therapists, whoever's treating you, as long as everyone is giving the insurance company an opinion that you should be off work, then the insurance company should agree to keep you off work. If you are already on short-term disability, there's really no reason why you can't proceed on long-term disability, because the test to be on short-term disability is the same as the first 2 years of being on long-term disability. The test is this: can you perform the essential tasks of your own occupation? That's the test to get short-term disability. If you got that, if you got over the line for that, you got approved based on that, you should be getting approved for long-term disability, at least initially. Beyond the 2-year mark, the test becomes a bit more difficult. It's can you perform the duties of any occupation for which you're suited for by training, education, or experience. So typically that's where there are some issues. But transition from STD to LTD should not be an issue, but I have seen that happen. Remember, you may have a different adjuster. Maybe the adjuster for the short-term disability insurer, maybe they said, yeah, we think you're disabled. And maybe the adjuster that's looking at your LTD application may see it differently. If you get denied, you come to me immediately. I will tell you what your options are. I will tell you what you can do. I will explain the process, but I can tell you that in many, many instances, we don't even have to go through that process. As soon as we're involved, the insurance company backs off. Not always, but it happens quite often. In terms of what to tell them, again, just stick with the truth. Stick with the truth. Tell them exactly what's bothering you. Don't inflate it. Don't under-report it. Just tell them exactly what's going on. And just rely on whatever your doctors are saying, and you should be okay. Okay, another question here. I had health benefits through my wife's work. I had a liver transplant a month ago. The transplant program required her to be full-time care person. She applied for family caregiver, but her job canceled her benefits. She's a union worker with schools. We're in Alberta. Is there something we can do to keep her benefits? So I can tell you this. This is more of an employment question, but because she is a union employee, she must go through her union. For employment matters, external lawyers like myself, unfortunately, can't intervene. For disability matters, we often can. We can represent people who are having issues with their disability insurer in a disability context, even if they're unionized. But in employment matters, and this is, again, I know you're dealing with benefits here, but it's still an employment issue because it's part of her compensation that she's supposed to be getting these benefits. So my suggestion is reach out to the union. The union should be able to help. If the union doesn't help, I suggest you reach out to the Ministry of Labor in Alberta and seek guidance from them. Okay. Question here: what insurance company is the best? I can't tell you which one is the best. I can tell you that we've dealt with all of them. It depends on the adjuster. That's the reality. Of course, there's some insurance companies that are more difficult than others. I have to be careful on what I say here because, as you can imagine, they're probably listening. They listen to many of our things here, and they can easily say you're defaming us. I will tell you this. when we are dealing with an insurance company that has wrongfully denied or wrongfully cut off a person from disability, it matters not who the insurance company is. I don't care what their bottom line revenues are. I don't care if they're making $100 billion a year. We will treat them as an adversary that needs to be defeated. If our client deserves the benefits that they deserve, we're going to go after them. There's no question. So there is no such thing in my mind of what is the best company. I'll tell you this, even when it comes to our firm, even when it comes to, personally, home insurance, car insurance, I don't actually have a favorite insurance company. I don't. And I've litigated against all of them, literally all of them across the country. Because at the end of the day, the law is the law. Some insurance companies, like I said, are more difficult than others, but typically, I can tell you that there's one insurance company that has a name. They're one of the biggest ones. They're considered to be some of the most difficult insurer and adjusters in the country. And I can tell you, I've had them as my insurer for my home and my car, and we've had claims, and I've had no issues. And not because of who I am, just because the adjusters I was dealing with are reasonable. So, it's a luck of the draw. I love this one. Do insurance companies ever get in trouble for making people's lives difficult? Excellent question. So when we make claims for short-term or long-term disability denials, we look at the conduct of the insurance company, because I can tell you that insurance companies sometimes legitimately believe that the person has no claim, legitimately believe that they should be issuing a denial or stopping benefits. And you know what? That's okay. That they're entitled for that. I may disagree with them, and I'll go after them for benefits, and I'll get those benefits. But sometimes it's clear cut that the insurance company is acting in a very malicious way, in a high-handed way. I'll give you an example. I've had cases where the insurance company had sent my clients, before they retained me, to their own doctors. So these are insurance doctors, okay, that the insurance company sent this person to for an assessment. And the insurance doctor came back and said, no, this person is disabled. They have this illness or this injury, whatever. They can't work. Despite that, the insurance company still maintained their denial. Well, when your own doctor that you've hired, that you've handpicked, is saying that this person is disabled, and you decide to override that because you think you know best and you don't have any medical training as an adjuster, that's when I'm going to go after you, not just for my client's benefits, but for what we call punitive damages, aggravated damages. These are types of damages that are used to punish the insurance companies, to claim for exacerbation of what my client is experiencing. And I can tell you that we have precedents across Canada where courts have knocked insurance companies and forced them to pay a lot more than just the benefits. And they hate that, by the way, insurance companies. And the reason they hate that is because that often makes the paper, that often makes the news, it makes them look terrible. I've been involved in some high-profile cases over the years, and one of the things that I find, and I know this anecdotally from lawyers that are friends of mine on the defense side, is that whenever these kinds of negative stories about insurance companies hit the papers, well, guess what? People stop using them. People start going to them for products. It doesn't last, but the point is that the damage to insurance companies is more than just the legal damage of the actual case. There's also damage in terms of people not wanting to use them for a period of time. So, there are ways that we can go after insurance companies for making people's lives difficult. But keep in mind, it's on a case-by-case basis. If we see that as a team, me and my lawyers and I can tell you that we take that very seriously, and I can tell you that we've gone after insurance companies and we've made their lives miserable, the adjusters that have caused this. I often tell people that, if your adjuster, if you have heart palpitations, if your adjuster bullies you, if your adjuster makes your life miserable and then you get cut off, you just wait until I get in that office with that adjuster, because I get to question them. And I'll tell you, I love nothing more than making them really, really uncomfortable. And I've had some stories. I can't tell you because they're within a confidential setting, but they're not as smart or as powerful or as strong as they seem once I get them in that chair. Okay, Gladys. My husband has been on disability for almost 2 years, and his adjuster has been really aggressive about a return to work. We don't think that he's ready. What happens if he goes back and it doesn't work? Excellent question. Number one, aggressive adjusters. I want you to record all your conversations with these adjusters. You don't have to tape them like as a tape recorder, but make sure that you record in a notebook send an email shortly after the discussion, after the call, to the adjuster saying, I don't appreciate the tone, or this is how you spoke to me. Make sure you say to your doctors, you convey to them, to your doctors, that this is how your adjuster is treating you, and it's exacerbating your condition, your anxiety, your depression, whatever it is. It's important because if I end up getting involved or a team member of mine gets involved, we're going to look back at those medical records and we're going to use that as support to go after punitive damages against the insurance company for the fact that they made your life a living hell. So I just want you to understand that you have rights here, and the adjuster has zero rights to be aggressive towards you. In fact, the insurance company, your insurance company, has an obligation to treat you in good faith, in a respectful manner. Now, I want to deal with the substance here. Return to work. Oftentimes, people will call me and say, I am not ready to go back to work because of whatever reason. My doctor agrees that I'm not ready to go back to work, but my adjuster, my case manager, is adamant that they want me to start a return to work program. Here's the answer. No. You will follow your doctor's advice, and you will tell the adjuster that you're going to follow your doctor's advice and that you're not ready. Now, if your doctor thinks it's appropriate for you to start a return to work program, different story. You got to work that out with your doctor. But if you and your doctor agree that you're not ready, make sure your doctor puts that in writing, give it to the insurance company. The insurance company can't force you. People tell me my insurance company is forcing me to go back to work. No one's going to come to your home, put a gun to your head and tell you you must walk out and go to work. Here's what they're going to do. They're going to say, if you don't try, we're going to see that as a breach of your obligations under the policy, and we're going to cut off your benefits. Nope. Sorry, doesn't work that way. If your doctor says that you are disabled, that you remain disabled at this point, and not forever, but just at this point in time, and you convey that to the insurance company says, well, guess what, Gladys? Your husband's going to get cut off on May 31st because he's not following our direction. Once they set up that cutoff date, that is called a breach of the contract, okay? It's actually called, the actual legal term is anticipatory breach, because they're anticipating, there is an anticipation of a breach now. They're saying we're going to cut benefits, and they can't cut off those benefits because he's still disabled. And so I tell people, look, stand your ground. If your doctor is behind you, if your doctor is saying you cannot work, you make sure that you convey to the insurance company, this is what my doctor says. I'm going to follow what they say. I agree with what they say. I cannot go back at this point in time. And if you take any action against me, then guess what? I will go to Samfiru Tumarkin. I'll contact Sivan. I'll contact a member of his team. They know us. But if anything like that happens, get in touch with us. I want to mention something else here before I go on to other questions. We're doing this Facebook Live. I answer questions all the time by email, by phone. Never, ever hesitate to reach out. Never hesitate, okay? No question is dumb. No question is stupid. This is foreign to most people. What insurance companies understand is that people are under tremendous amount of stress. Their families are under tremendous amounts of stress. And they play that. They use that against people. They know that they can shake off people off claim, that people will say, I can't deal with this. I can't. Just leave me alone. I'd rather not have this money. I just don't want to deal with it. I can't. This is what they're hoping for. And so what I tell people is, reach out to us. I'm not saying retain us. I'm not saying hire us. None of that. Reach out to us for advice. Speak with myself, with a member of my team. We will tell you where you stand, what your claim is like, what your insurance company, whether what they're saying is correct or not, whether they can force you to do this or not. We will give you the information you need. You do with that information what you want. If you want to fight them, if you want us to fight them, by all means. But I want you to be empowered. I don't want you to feel that you are powerless. And this is the biggest misconception here. Insurance companies want you to feel powerless. You are not powerless. It's a mirage. I'm telling you this as somebody who worked for insurance companies for years. It's a mirage. Insurance companies understand that this is the psychological warfare, and they're doing this. And the majority of people just give up. Do not give up on your rights. Whether I help you, another firm helps you, whatever. Do not give up on your rights. If there's money owed to you, it's owed to you by law. I want to go here. Tyler, I am diagnosed with agoraphobia, panic disorder, and CPTSD. My doctor suggested I go to grocery shopping with my parents as a form of exposure therapy. A few months later, I got a call from my insurance company saying that they have video of me walking to a grocery store. They said it contradicts what I told my doctor and what I wrote on my LTD application form. Is there any way I can fight this? Okay, excellent. Number one, there's a lot of conditions you're suffering from, and I'm sorry for that, Tyler. Surveillance. Okay, insurance companies use that to gaslight people. I used to order surveillance when I worked for insurance companies. Most surveillance is useless. Not only useless, most surveillance actually contradicts what the insurance company is saying. I wouldn't worry at all about what it is that you're describing to me here right now with what the insurance company has found. The fact that you went with your parents grocery shopping, listen, let me give you a more extreme example. I have people contacting me saying, I suffer from stress, anxiety, whatever the issue is. My family doctor says it's good for me to go 3 times a week swimming or going to the gym or whatever it is that they tell me to do. And I did that. And the insurance company had surveillance on me, a private investigator who took photos and videos. And guess what? Now, the insurance company is telling me that this contradicts what I told them, and they're going to cut me off. No, it doesn't work that way. If the doctor told you to do something and you're following doctor's advice, you are actually doing exactly what your insurance policy says you should do, which is follow your doctor's advice and treatment recommendations. But insurance companies, again, will use that. They'll use anything they can. They will latch on to anything they can. I had a client once who suffered from a neurological issue, and he was denied benefits. And there were, I think, 12 or 13 grounds of denial. One of them was surveillance. 12 or 13 reasons that they gave him. The letter was, I think, 8 pages long. We're cutting off your benefits, they said. 8 months later, we had a settlement for him for over $300,000. So my point to you is, again, not every case is the same. Cases are different. Insurance companies will throw whatever they can at the wall to see what sticks. And it is oftentimes psychological warfare. Psychological warfare. I know they don't like me using it because it makes it look like they are doing something that is illegal. In my view, they are. In my view, when an adjuster is being aggressive, bullying, that is aggressive and bullying behavior, which is not allowed under the policy, not allowed under the law of insurance company and insured relationship. And to me, that is a breach not only of the policy, but of the law. We can go after them for that. Do you deal with a lot of cases where CPTSD, like childhood trauma, is diagnosed as an LTD, still able to be paid if they say it's pre-existing? How do you fight that? Excellent question. Pre-existing issues are a big issue, obviously, that comes up. But again, it requires us to go into detail into what we're dealing with. I'll give you an example. I've had clients with childhood trauma, or even trauma not from childhood, but from many years ago. And so the insurance company says, well, no, this is pre-existing, this depression that you're having right now, and so we're not going to pay it. Okay, let me give you a different example. Car accident, which we handle as well, car accidents, personal injury. You have somebody who experienced a sports injury to their back, let's say 10 years ago. Okay, they've healed, not 100%, but enough to do their job. A week ago, there were another car accident, and that aggravated that pre-existing injury. In fact, but for the initial injury, maybe they would not have been injured as much as they have been because of this car accident. So they were vulnerable because of the pre-existing issue. So now the insurance company says, well, wait a second, you had a back injury 10 years ago. That's pre-existing. We're not going to pay you. No, it's not the way the law looks at it. If that person was unable to work as a result of that initial back injury 10 years ago, and now there was another injury, well, yeah, okay, it's difficult to say what's going on, but the reality is the person hasn't worked since 10 years ago. But if the person got better, was able to function, and now something else triggered this condition, it's not pre-existing. Sorry. It's a person who has a vulnerable condition. It's a person who has a condition that makes them susceptible to injury, but it's not a pre-existing condition. And so pre-existing has a very narrow definition. And insurance companies sometimes trigger pre-existing denials incorrectly. I'm not saying all the time. Sometimes they're legitimately denied. But in many cases, we can circumvent and argue the pre-existing condition. And so I'll tell you that when you're dealing with childhood trauma, you're dealing with other types of conditions, psychological especially, we can often help. But I need to understand more. I need to see the condition. I need to understand the details because it's very, very fact-based and fact-driven. I need to really, really kind of sink my teeth into it. I can guarantee you the attention we put on claims and talking to people about their situations, oftentimes is in a lot more detail than other individuals, than insurance companies and the adjusters. And by the way, these adjusters are handling easily in excess of 100 files at any given point. So just imagine how many files they can possibly deal with and how much detail they can go into. We're just about done here, but I want to address another question here. If my psychiatrist says that I'm able to return to work with temp work from home accommodations, can health services at work say no? That is an employment issue. I can tell you that there is issues of accommodation. We have employment lawyers in our firm, so feel free to reach out after the live stream and I can put you in touch with the right person. And that's, by the way, one of the unique things I think about our firm is that we really focus on disability law / injury law, but also on employment. And so oftentimes those two intersect, and we have lawyers that specialize in both as well, so we can help you with that. We are now at the end of the live stream. Thank you all for joining. If you want to find more information, go to disabilityrights.ca. We have other live streams. Please follow us and send in your questions. The next live stream is on Thursday, April 10th, which is tomorrow at 2 p.m. Eastern Time with Jeremy Herman, one of our star employment lawyers. Please tune in and thank you very much.